We'll tell them what the consequences are if you don't do this. We tell them, the judge is going to ask you, why, if you're depressed, why are you continuing to smoke marijuana when your doctor told you not to? So we're not going to tell you you have to stop. We're just going to tell you that this could be a speed bump in your case that we have to deal with.
Right. And you use the word speed bump nicely. It could also be a huge brick wall that we're going to be running with your case.
Yeah.
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. You weren't actually hired to be the bank keeper of the disability trust. Now, I get why they feel that way, and most judges, I can appreciate why they feel that way, but I don't think that's really part of the legal criteria of what they were hired to do. But that's just my opinion. But I don't want to deep dive into that. I don't want to go off the cliff on that too much. So the number one type of case is under 50. What's the number two one? It was mental health is what we kind of talked about. Mental health only cases, and mental health meaning depression only, or anxiety, PTSD, personality disorder, schizoaffective disorder, schizophrenia, those types of diagnoses. And if that's your only diagnosis is something in the mental health, they can be difficult to win. And why do you think that?
Well, I agree, Peter. Mental health only are probably certainly one of the most difficult cases to win, because you don't get the benefit of what we just talked about. And so for the average person, they don't really understand this idea of aging, but we call that the grid rules. It's the grid rules is really what we were talking about with respect to age. And so as you get older and you can lift less and you can stand and walk less and you're not physically as strong, Social Security recognizes that. But if you've only got mental impairments, that's not going to necessarily be a presumption if you don't have an exertional or physical problem. So mental health issues, there are some mental health issues that are really kind of out there, and a lot of them have been discredited. And one example is multiple personality disorders, which were very popular in the early 90s. And people would say, remember Sybil, I've got Sybil's disease. I hear I've got all these different personalities and so forth. That is going to be pretty much disfavored, I think, as a mental health diagnosis anymore. I've actually represented people who have been diagnosed with multiple personality disorder and dissociative disorder. That's another one, dissociative identity disorder. I just did a case yesterday where the claimant had a dissociative disorder, and that kind of goes hand in hand with post-traumatic stress disorder. That's also kind of a tough one, because you have to have a stressor event. You have to have something that was life-threatening to you having occurred. And a lot of the cases I see now for post-traumatic stress disorder relates back to when they were a child. There's not necessarily a lot of veterans seeking disability for that anymore. There were, let's say, post-traumatic stress disorder used to be recognized as a delayed onset mental health disorder. In other words, 20 years after is about what they would figure, 20 years after your stressor event. So let's say you were in Iraq, when was that? That was that 20 years ago? It might have been, yeah. So if you develop post-traumatic stress disorder because of your experience in the military, and it was 20 years ago, that would have been a pretty clear case of post-traumatic stress disorder a few years ago. But they've changed the criterion now, and they have a category called acute onset stress disorder, and that would be something that you've got, but you still have to have the stressor, but it could be much more recent than 20 years ago. Let's say you have a car accident 2 years ago, and you're afraid to drive after that, and you saw something terrible, like you saw somebody die, or somebody close to you was severely injured. Well, you could develop post-traumatic stress disorder from that. And I think it's good that it's recognized now that it doesn't have to be 20 years ago like it was when I was a judge. Yeah.
Right.
So,
what you're saying is these are just tougher cases to win because of the way the regulations are written. Not that you personally believe like it's over
correct.
years ago, or, it has to, and obviously what you're saying too is it's not just, and correct me if I'm wrong here, but I've seen acute stress disorder cases, not just from life-threatening disorder or life-threatening circumstances. It could be from childhood abuse, physical, emotional, sexual abuse that's happened to someone, and developing PTSD. Maybe their life wasn't like that of a soldier in the military.
DV is a really good example. Domestic violence, that can create a really severe post-traumatic stress disorder. And it would also be understandable that it would create anxiety and depression. And, it's kind of an insidious disease, really, when you think about it, that we didn't used to recognize.
Right. And now, but it's good because we're moving forward. It's same with the Social Security Administration is moving forward. One of the things that I think makes mental health cases tough, that we run into from time to time with clients, is that, especially if it's like depression and anxiety, agoraphobia, or hints of, social anxiety, is that you run into folks a lot of times who, and I want to encourage our listeners to know, if you suffer from depression or anxiety, we get it, in a lot of levels. I will be the first to say that I'm not a human being. I mean, if I couldn't tell you that I've never been depressed. Of course, I've had bouts of depression. Not to the severity that it's kept me from working, but at some points, my dad passed away. I remember taking a year and feeling very depressed through that, and having certain events come up in life that caused that. So one of the issues that we face that make these mental health cases tough is that there is an expectation from Social Security designed in the regulations that you seek medical treatment, you create medical records, and you help yourself get better.
Yes.
People who suffer anxiety and depression aren't always on top of making it to every appointment. They're not always feeling up to getting to the appointments. They're sometimes not up to taking their medications. Mm-hmm. And so that makes it even more complex when you're trying to describe that to a judge, saying, look, I get she missed 6 appointments in a row, or, but here it's part of the mental health component, and not every judge is super understanding to that, which makes it one of the more difficult cases to win.
Yeah. Well, and bipolar comes to mind because people with bipolar disorder, they tend to not take medication, because bipolar is depression and then hyper whatever. You become a lot of energy, and so it would be the opposite of depression, I guess. And they like that feeling of being high naturally, and it's worth it to them, to go through the depression if they don't take the medicine. So, and as a judge, if you're not, if you have a mental impairment and you're not taking medication, that's going to be a strike against you. Intermittent medication is one thing, but not getting your prescriptions filled, your notes in your files say the doctor has told you. Alcohol is another good example. The doctor's told you not to drink alcohol, or the doctor, you've got some sort of schizoid or depressive disorder and you're drinking alcohol. Even if you're taking medication, that alcohol is going to overcome the positive benefits of medication in a lot of cases.
Yeah.
And it's going to depend on what your therapist or psychiatrist says.
Yeah. And I just want to make this point up front for anyone who's listening to this, is that we represent a ton of people under the age of 50, and we represent a ton of people who have mental health impairments only. And that's why you hire our firm, is to go to fight for you. And if we only took on the easiest, right, we wouldn't be growing. And the fact is these are cases that I think spark our interest sometimes even more, because they are more difficult to win, and we love to fight for those folks. And in mental health cases, we just need to cross our T's and dot our I's. We just need to make sure, encourage you to get your treatment, reach out to your professionals, request a psych CE if needed, doing those things, getting RFC questionnaires filled out. But you brought about, go ahead.
I was just going to say, we don't tell people, you have to do this or you have to do that. But we will tell them, and I always do, and I know you do too. I think all of the attorneys in the firm do this. We'll tell them what the consequences are if you don't do this. We tell them, the judge is going to ask you, why, if you're depressed, why are you continuing to smoke marijuana when your doctor told you not to? So we're not going to tell you you have to stop. We're just going to tell you that this could be a speed bump in your case that we have to deal with.
Right. And you use the word speed bump nicely. It could also be a huge brick wall that we're going to be running with your case.
Yeah.
That brings up the number 3 thing of some of the more difficult cases to win, which is, and you brought up alcohol, but DA&A. And why don't you explain the DA&A rule, generally speaking, and how it works in Social Security, and then we could talk to our listeners about its application.
Okay, so the DA&A is the shorthand for drug and alcohol abuse. And there is a regulation that has been around since, I think, about 98 that says that if your impairments are the result of drug and alcohol use, then you may be completely disabled, but you're not going to be eligible for benefits. And as that rule has evolved, now it's to the point where if it's a substantial factor in your mental health impairment that is related to your drug and alcohol use, then that is going to be held against you, and it probably would disqualify you from receiving benefits. Now, there are a number of ways to deal with that, and one of the ways is if you are clean and sober for a period of time, and I think the minimum that most of the judges would require of clean and sober is going to be about 6 months. But let's say you suffer from depression, and let's say that you are drinking more than you should, and your doctor has told you, you probably shouldn't be drinking so much if you're depressed, and it's in your records. let's say you stop drinking. Let's say you stop drinking for 3 months. Well, if you improve after you've stopped drinking or smoking marijuana or using methamphetamine or whatever, if you improve, then that's going to show that the drugs and alcohol were a material factor in your disability. It's a real catch-22, because if you improve, you would think, yay, I'm getting better. But the fact is, it hurts your case if you improve. If you don't improve after you've stopped, and you can prove that you stopped by either UAs or your medical records, consistency, credibility, all those things that are considered. If you don't improve after you've stopped, then obviously the drugs and or alcohol were not causing your disability. So that's going to, if you don't improve, it's going to increase your chances of prevailing on your claim. But it's a very careful analysis that the judge has to do, and it would be very unusual for a judge to make that decision about whether drugs and alcohol are material to your disability without some expert advice. And that's usually going to be either an agency psychologist who looks at you and completes a form called a PRTF, or your own doctor, or possibly occasionally a medical expert. I have seen judges, and when I was a judge, I used psychologists to tell me, is the drug use or the alcohol use a cause of disability here? And unless you've got a period of sobriety or cleanliness from drugs, it's going to be very hard to answer that question. And that the burden of proof is on you to prove disability. And because of that, a judge can decide against you unless you can show that your disability is not the result of drug and alcohol use.
Yeah, or made worse by your drugs and alcohol use, for lack of a better, for
Right.
layman.
Yeah.
Well, one of the things I'll say, just kind of to include, is I think very plainly, drugs and alcohol abuse and mental health make those two types of cases. If DA&A is involved with your mental health, makes it even more difficult to prove mental health. The second thing is, it's not only in mental health, just for our listeners out there. So if you're thinking to myself, well, okay, my issue is not mental health, but I have liver disease, or I have cardiac issues, or kidney disease, or a seizure disorder, right? And I've seen specifically alcohol in those, in physical cases, be a major issue, in certain cases. And especially like a seizure disorder, and then in the record, you're saying this is alcohol-induced seizure, and if you see that sporadically throughout the record, man, that's a physical case, but difficult to win.
Yeah.
We recently had a case with liver disease, where the person drank themselves to disability, but then stopped. But because the liver can't heal itself, unless you get a transplant, we were still able to win disability, even though the alcohol was a direct cause to the liver problem. The person stopped drinking, which was a really important factor in this case, got on the wait list for the donor. But still, just all of the symptoms of the years and years of abuse on his liver cause this person to be found disabled. And go ahead.
Yeah, that's absolutely, the damage was done. And so we're more likely to see a little more frequently, I think, where somebody has abused methamphetamine and then they stopped. But after they stopped, they still had psychotic episodes, or the methamphetamine caused them to have intermittent psychosis, and if they have actually stopped and they've got severe psychiatric disease, they're probably going to prevail and get benefits. But that would depend on whether the judge believes that they've stopped, and that's why it's not unusual for me to ask some of my clients to try to get a urinalysis within 30 days. Yeah.
A side note to it all too is, even if you win your disability case, and we've won plenty of cases where people are actually actively using or abusing DA&A, we could prove there was a point of sobriety and they were still disabled, and the judge, agrees and then a medical disability. But if you're actively using, it is more likely than not that either the judge or the Social Security Administration is going to see that in your file. And on a side note, you're going to be assigned a representative payee who manages all your Social Security money. And so you can look forward to that if you can't get sober. And most people hate that. I mean, unless it's like their brother who's managing their money. But, if you get a professional payee, they have a fiduciary duty to kind of pay your bills and look out for you. So, I meet clients on average probably once a month, maybe once every other month, that reach out to us and say, hey, can you get rid of my rep payee?
Yeah.
And I ask them sober.
Well, and bear in mind too, Peter, that we're still on the topic of mental impairments only, because you can be actively using drugs, but if you have exertional impairments, physical impairments also, then it's not the kiss of death.
Right. So so physical impairments with DA&A, it is not the kiss of death, because it doesn't have, like, if you're smoking pot all day, and I just recently did a podcast with Mervin, and I think what the three of us should get together, it might be a really interesting conversation about marijuana and different things we see or read or heard about, and maybe how it's treated by Social Security, but maybe how it's treated by the states, doctors. Have a very interesting conversation. But with that DA&A, like, if you're smoking marijuana and you have a back issue, I don't know of any study that's going to say, oh, marijuana has a substantial impact on your back and neck disability, right? So it shouldn't be taken into consideration by the judge. One thing that might be taken into consideration could be credibility, right? Because marijuana is not legal at the federal level, just like a criminal background. We're going to talk a little bit about maybe numbers, DNA, and then also criminal background. Sometimes those can be really difficult to win because it's just an issue of credibility. And a lot of times it depends on what you're convicted of too, right?
Yeah, exactly. Yeah. You want to, should we talk about that? Yeah.
Yeah, let's talk a little bit about criminal background and DNA and relation to credibility, maybe.
Okay. Well, so as far as the kiss of death, if you have a crime in your past, a crime of moral turpitude, as they call it in the law, where let's just say that you have embezzled money from an employer, or let's say that you were caught getting food stamps illegally. Those kind of fraud type crimes are really frowned on in the law across the board, because they show a lack of I'm not quite sure how to say this, but they show
credibility.
Well, exactly. Totally. Yeah. I mean, if you're going to lie, it's like when you're a trial judge and you've got let's say you've got somebody in front of you who, lies about something and it's insignificant, but it shows that they just can't be believed. That's the same thing's going to carry forward in one of these hearings, because credibility is really important. Now, the other thing about crimes and having a criminal record, it's difficult to get a job. It's difficult to get a job with a felony on your record. And Usually, I think people are pretty honest about that. They'll say, the judge will ask them, well, have you applied for jobs? Yes, I have, but I can't get hired because I have a felony on my record. Well, that's not the same as being disabled. You can't work because you have a felony. That's not disabled. That is a consequence that society requires of you for having engaged in felonious activity. So that's something that if you have a felony, it's not going to help for your case. It's not insurmountable at all. If you've got some physical problems, then that's something that is certainly going to be taken into account. And when I was a judge, I mean, I'm sure I put a number of felons on disability because they had other problems. I recall one case in particular where a claimant had heart issues that were real severe, and he had multiple felonies. He'd spent 20 years in prison as an adult, but he had heart issues that prevented him from being able to work. In fact, I think he was like 51 or 52, and so he gritted out. He met that over 50 requirement that required a finding of disability. So it's not always the kiss of death, but it's not going to help your case.
Yeah, I mean, everything we've talked about so far, whether it was under 50, mental health, DA&A, criminal background, we represent everybody in those.
Yes.
So, and we take them on because we believe we can be successful. We believe we can make a difference, and we're very hopeful that we can win. We don't get paid unless we do. It's not
right.
We by the hour. So unless we win, it's contingent. We win if the claimant wins, and if we don't think the claimant can win, we typically don't take them on.
Right.
The other thing, different criminal cases, it's important to note, if you have an outstanding felony warrant, you're not even eligible for Social Security disability benefits of any kind. You're just
right.
It's also important to note that, if you do have a crime of dishonesty, theft of government funds, Social Security fraud is an actual crime, or embezzlement, and there's this restitution out there, and you owe money back to the courts, and you're in collection status, even if you win your Social Security case, they're going to come get it from the money is going to be used from your Social Security case that you win to pay off some of your restitution if it's in collection status. So that's important to note as well.
Yeah, and one other thing in that same vein is, let's say you just got out of prison and you've been incarcerated for a period of time. You do not collect benefits while you're incarcerated because the state or the government is already supporting you during your period of incarceration. So that's just something to bear in mind as well.
Right, that's correct. So a lot of times people are like, I got out of jail yesterday, let's apply. Okay, but you don't get the back benefits if you've been in jail for the months you were in jail or prison. You don't get back pay for those months going forward. The number 4 thing that we talked on the most difficult cases to win is fibromyalgia. And